Just to say good morning, everybody, and welcome to this webinar in which Carl Calvert and I are going to look at boundary determination, both under the determined boundary jurisdiction in the Land Registration Act, and then also perhaps more generally a little later on. I'm delighted to have Carl with me. He'll need no introduction to many of you. He's obviously a very experienced boundary surveyor. But he's also on the RICS Boundaries and Party Wall Working Group. He was the co-chair of the committee producing the latest RICS guidance on boundaries. And he's also the RICS representative for land surveys on the Land Registration, the Land Registry Rules Committee. So more than qualified to discuss matters of this kind. And he also has grey hair. He has. He does, but that's experience, Carl, obviously. Sign of experience. Thank you. I've also had the pleasure of working with Carl on many cases over the years, but most recently we've been involved in a case called Woodhead and Witt, which ended up before Judge Elizabeth Cook in the Upper Tribunal at the end of last year. We're going to look at some of the issues in that case in a while, because they're helpful to explain the sorts of problems that you come up against in these kinds of applications. But before we do that, we'll look at the jurisdiction. Just remind ourselves of the jurisdiction, the statute and the rules briefly, one or two comments by judges on them. And also, importantly, the Land Registry Practice Guide regarding determined boundary applications, which features heavily, as you'll see, in the way these applications are dealt with. So let's have a look then at the jurisdiction and some of the slides that I've got here, which just set out the basic provisions. I mean, there are obviously extensive provisions, but what I've done here is to highlight the important parts of them. Section 60, first of all, is the primary jurisdiction. The boundary of a registered estate is a general boundary, unless shown as determined under this section. And as we all know, a general boundary does not determine the exact line of the boundary. And then rules may make provision enabling or requiring the exact line of the boundary of a registered estate to be determined. So let's then look at the rules. And the first one is Rule 118. A proprietor of a registered estate may apply to the registrar for the exact line of the boundary to be determined. An application must be informed DB and accompanied by a plan or a plan and a verbal description and some evidence. And then Rule 119 is important. Where the registrar is satisfied that the plan or the plan and the verbal description identifies the exact line of the boundary claimed, and that the applicant has shown an arguable case that the exact line of the boundary is in the position shown, and he, the registrar, can identify all the owners of the land adjoining the boundary, he must give the owners of the land adjoining the boundary notice of the application and of the effect of paragraph 6. And paragraph 6 says that unless any recipient of the notice objects to the application within the time fixed by the notice, the registrar must complete the application. And then in paragraph 7, where the registrar is not satisfied as to paragraph 1, the various provisions that we've just looked at, he must cancel the application. So we see immediately that there's a fairly binary process here. The jurisdiction is basically for the registrar to either complete the application or cancel the application, which doesn't leave much room for the sorts of other matters that arise, as we all know, in boundary disputes. And so the courts had been invited to express a view about the extent of the jurisdiction. And the first case in which that was done was Murdoch and Amesbury in 2016. His Honour Judge Dite sitting as a judge of the Upper Tribunal. And he said, in my judgment, the correct analysis of these provisions is that the scheme intends that the outcome of the application will be completion or cancellation, not a general determination of boundary issues, which is entirely consistent with the rules as we've just seen them. So a very clear interpretation from Mark Dite there. But in the same year, Judge Elizabeth Cook, in a case called Bean and Katz, put a bit more of a gloss on it. She said, there is no doubt in my mind that the first tier tribunal has jurisdiction to examine the title to the land concerned, to decide the success or failure of the determined boundary application on the basis of the decision as to where the boundary lay, and to direct the registrar to give effect to the application subject to that specific direction as to, and this was a part of the boundary, in this case, the front section of it. So she sort of extended the potential jurisdiction a bit here. So the tribunal has jurisdiction to direct the registrar to do something more than just simply complete or cancel the application. And Paul Morgan, Mr. Justice Morgan, agreed with her 2 years later in a case called Lowe and William Davis, where in that case, the appellant's counsel had submitted that it appeared that initially the FTT had jurisdiction to determine the location of the boundary, but when there was a question as to the accuracy of the plan, the FTT was then constrained to decide that point as a preliminary issue, and having decided that the plan was inaccurate, the FTT lost jurisdiction. Well, Mr. Justice Morgan said, I don't agree, and in fact agreed with what Judge Elizabeth Cook was saying, which was the jurisdiction was wider than that. And then most recently, in the case that Carl and I have been involved with recently, Woodhead and Witt, in the early part of her judgment, Judge Elizabeth Cook, in setting out the law and the procedure, said, if the FTT regards the boundary sought as partly correct, it may direct the registrar to give effect to it to that extent, but to reject it insofar as it is incorrect. And it may give a direction about the entry to be made with regard to that part of the boundary where the applicant's plan was found wanting. So she's put a further gloss on her interpretation, which is that therefore there are further options other than just cancellation or completion, and a bit more discretion within the jurisdiction for the FTT to direct the registrar accordingly. So the current position, it would appear, seems to be as follows, that the two binary options: complete the application, cancel the application, or thirdly, direct the registrar to complete the application in part. But still, as you can see, a very limited jurisdiction. Then we come to, as I say, the guidance from the Land Registry, which is an important part of the process. And again, there's a lot more to it than this, but what I've just done is to distill this down to some important aspects with regard to the preparation of the determined boundary plan. And you can see the sort of constraints upon the preparation. First of all, it must be accurate to plus or minus 10 millimeters on the ground, which is a remarkable accuracy, and Carl will have some views about that in a moment, I know. Measurements taken horizontally, not along a slope, and they must be taken from at least 2 defined points on surrounding permanent physical features. So some fairly restrictive practice there. So Carl, over to you then, if you would, and just help us with your thoughts and observations and the practicalities of dealing with determined boundary applications and drawing up plans, particularly from a surveying point of view.
Okay. Right. A determined boundary needs measurements to where and from where. Here we have an example. I'm not quite sure whereabouts it is in Britain, but it just shows somewhere in splendid isolation. And if the person wanted a determined boundary, the question really arises, where are the measurements going to be to adjacent properties? It's not always that easy. I was fortunate enough to be the RICS representative to Land Registry when the rules were being considered and Practice Guide 40. And I did say that 10 millimeters accuracy was extremely difficult and very costly. And perhaps one of the reasons why in the 1925 Act, the fixed boundary failed was because of cost. And to date, there have been very few determined boundaries in land registry compared to the general boundaries or boundary agreements. So this is from an RICS measured surveys. It's also in another journal, but you can see that D1 sigma. So the question is, what is sigma? It is a standard error. Great. What's a standard error? It means that there 68% of errors are going to be 10 millimeters or less. In other words, the probability is that it's going to be 10 millimeters, but 90% could be 20 millimeters and 100% would be 30 millimeters. So immediately you see, how do you explain to the court that it's accurate to 10 millimeters if there is a discrepancy of 25 millimeters? You can see that you've got this problem. And the other one is accuracy of hard detail is 10 millimeters and soft detail. Okay, what's soft detail? Well, that's soft detail. It's a Devon bank. That's fine. So where is the boundary on that? Is it at the base on one side or base on the other? Or is it in the middle? Do you measure to the top? You can immediately see that there are problems. Well, let's just go over the Tamar and then we have a Cornish hedge. And it's very much like if you have an afternoon tea with scones, do you have it with the jam and then the cream on top, or the cream with the jam on top? Or the Cornish hedge, this one has stone rather than turves. Same problem arises. So now we get to a modern stone wall. You've got a regular edge, but one stone is probably more than 10 millimeters different from its neighboring stone. And at what height is the measurement really taken? Because 10 millimeters is very little. Over to you, Simon.
That was very helpful, just demonstrating some of the problems about the accuracy required from a surveying point of view and preparing the plan. So we're starting to see the sort of problems that might arise in these cases. And in fact, it's helpful to, I think, just look at Woodhead and Witt, the facts of it very briefly just now, so that we can sort of put some of these points in context. So looking at the facts or the issues in the case, there's the accuracy of the determined boundary plan, and we'll come back to Carl on that in a moment. But I mean, as with many boundary disputes, there were other issues in the case, as there often are, legal issues. So we had an issue about the construction of the transfer deed itself, the subject matter of the transfer. There was an inferred boundary agreement argument as well, as we'll see, and then our old friend adverse possession, which often, as we know, crops up in boundary disputes. So how are these going to be dealt with in the context of a determined boundary application? And to analyse these a little more closely, here's the determined boundary plan in Woodhead and Witt. And just to give you a brief outline of the context. So the two properties, numbers 82 and 84, were semi-detached properties built in the 1960s, the early 60s, by George Wimpey. And that when they were built, they comprised, first of all, you've got the street here, then there were the front gardens of the properties here, and the front walls across here. The properties actually at that stage went back to here and across and through that recess there. Those were the rears of the properties. And they were divided by a party wall, which ran through the chimney breast in the middle of the two properties. Since then, they have been extended, both of them. So the number 84 extension is this rectangle here. Sorry, number 82 extension. The number 84 extension is this one here. And then 84 has subsequently had a conservatory built on the back, which is this further rectangle on the back, which doesn't actually meet the boundary. But there was no issue about the boundary in the front gardens. It was accepted that the boundary ran from point A to point B on the plan. And indeed, through the, sorry, we've jumped ahead, through the party wall, through the chimney, to the back of the original properties. But when the properties were built, there was then a chain link fence, which ran from the rear of the properties here right down to the bottom of the garden, suspended by concrete posts. And in fact, the concrete post at the bottom of the garden at point D is still extant. And I've just lost my mouse for a moment. Sorry, there it is. So point D here, there's still the remains of the original concrete post. It's 8 centimetres wide. And what's interesting is that on the DB plan, you can see the cross where at point D, but that the applicant's DB plan showed that as being the centre of the post. So the first issue, or one of the issues, was, as I say, about the construction of the transfer, because in the transfer there was a covenant on the part of the occupant of number 84 to maintain and repair the fence. So if the boundary was the centre of the posts going down the back of the garden, that put at least half of the post inside number 82. How was the occupant of number 84 to maintain the fence and the posts without trespassing into number 82? So there you see the issue about the construction. And ultimately, Elizabeth Cook agreed with us that having regard to that construction point, the boundary must be the 82 face of the concrete posts, and therefore the plan showing the boundaries arriving in the centre of that post was wrong, albeit by only 4 centimetres, half the width of the concrete post. So that was one of the issues. As I say, were other issues. Adverse possession was always one of them, because the line you can just about make out. It's not easy to see on here, but there's a mortar joint shown marked on the plan just next to point C, which was the join of the two rear extensions. But curiously, the line shown on the plan doesn't go through that mortar joint. It goes to the number 84 side of it, again by about 4 centimetres. So that was another curiosity. And again, Judge Cook just agreed with us, and Carl will tell you a bit more about this, I'm sure, that having regard to all the circumstances, that couldn't be right. The mortar joint plainly was the join of the two rear extensions, which were built parallel to the party wall, and therefore the boundary must have gone through that point. So the adverse possession point was that obviously if the paper boundary showed the line inside the corner of the number 84 extension, which was built in around 1980, it had been there for long enough that any title in number 82 to it had been extinguished. So these are the sort of points that arise, and you know, the question is whether the determined boundary jurisdiction is capable of dealing with this. As we'll see in a moment what Judge Cook decided. But before we do that, back to Carl to tell you about some of the surveying aspects and problems in this case, and in particular in relation to the DB plan.
Right, thank you, Simon. Just get back to this. And here we have Woodhead and Witt. This is an enlargement, and the other expert did a survey, and there was a PDF file which I overlaid AutoCAD. But effectively what we have here is number 84, number 82, and I'm sorry, it's the reverse sense from Simon's plan. So we haven't got the house at the bottom, we've got the house at the top. You'll see I did the scale 1 to 200 to try to make it clear, but even then it was very difficult to show the detail of the mortar joint. Let's just have a look at it. You'll see here in blue outline, what I've done is also surveyed the inside of the wall. Basically, if it's a party wall, what is its width? How far does it extend? And there was an argument about, well, was the extension of number 84 that I'm pointing to now, was it actually on the party wall or not? So I had to go up into the loft to do some measurements. The other thing is we've got the conservatory of number 84 as surveyed by me from number 84, and we've also got the conservatory as surveyed from number 82, because I didn't go into number 82 and the other surveyor didn't go into number 84, and there's a difference. Now, basically that's not a great problem. It can be resolved, meeting of experts. However, on the DB plan, there weren't the two measurements required. So there was a fault in the original plan. Now, it's not for me to tell the other surveyor, I think that, you know, it's going to fail because of that. That's land registry. You can have a quiet word at a meeting of experts, but it's land registry, HMLR, who make the decision. Let's go on to follow this line. And this is an enlargement at 1 to 100 of this area of the mortar joint. You can see the red line, which is where I believe the boundary to be. You can see there are two blobs. These are concrete posts. And this is the conservatory, and this is the extension. And you can see the mortar joint. Now there are two arrows, one up, one down. One of them indicates where there is a nail in the soffit, right at the top of the building. It's a chalet bungalow. And the other one is where the mortar joint is. The reason for that is to show that the boundary is a vertical boundary. It continues. The question arises, why would number 84 have moved his fence and concrete posts into his land rather than on the boundary? The reason is, like most boundary disputes, he didn't want any more disputes with the neighbour. However, interestingly, there's a gutter that runs here from the extension. It runs, the downpipe runs through the fence to a drain and gully on number 82's side, which raises the question of, well, is that normal? And the answer is no. So you'll see on this that although there's not a lot of difference between my survey and the other surveyor's survey, there is a question of, did we fit in with the guidelines in Practice Guide 40? Were we looking at the ground sensibly? And was the accuracy there? So having said all of that, you can see that there are difficulties even in trying to do a survey to 10 millimeters. So I shall now pass back to Simon.
Thanks, Carl. Yeah, well, I mean, that just demonstrates some of the further issues, I mean, just from the surveying point of view. So unsurprisingly, in light of all those points, ultimately, Elizabeth Cook came to the view, and this was on appeal, remember, the applicant had succeeded in the FTT, but on appeal, and the appeal took the form of a rehearing, because, and this is another possible thing to take into account, the FTT at Alfred Place, the recording equipment had failed, and so we couldn't obtain a transcript of the judgment from the FTT. So at the permission application, which took place in front of David Hodge, sitting as an upper tribunal judge, he agreed with us that we should have a rehearing on the appeal. So the hearing in front of Elizabeth Cook was a rehearing. So she came to the conclusion, having heard all that, that she wasn't satisfied that the DB plan was accurate. But interestingly, and here's a summary of her decision, she found the inaccuracy 4 centimetres, as we've identified, at the mortar joint for the reason that we've discussed, and then another 4 centimetres down at the bottom at point D, where the concrete post was. But quite somewhat surprisingly, in light of her comments about the jurisdiction, her conclusion was, I see no purpose in directing the registrar to accept that part of the DB plan that is correct. That's to say the bit between A and B at least, since insofar as it is correct, it is uncontroversial. Accordingly, I direct the registrar to reject the application for a determined boundary. So we'd had 2 trials. Well, we'd first of all been through the land registry procedure, and then a trial in the FTT, a further trial in the upper tribunal. And after all that, and about 3 years of procedure, we got nowhere, effectively. But the applicant, their application was dismissed with costs, so they had to pay 2 lots of costs, although, of course, they don't pay 100% of them, but they paid the large part of them for the FTT and the upper tribunal. And as far as the respondent was concerned, he'd been through this procedure as well. His property had been blighted for 3 years while it was all going on. And even now, at the end of it, there's no clear determination as to where the boundary is, although, as Elizabeth Cook said, that she had made findings which obviously created an issue estoppel as far as these parties are concerned. But it remains to be seen if the respondent goes out into the market to try and sell his property, what the reaction of potential purchasers will be. Hopefully they'll take the view that things have been resolved at least to a sufficient extent that it's clear where the boundary is, but he's got no determination of it. And so after all that, as I say, a rather unsatisfactory outcome, you may think. So that then sort of raises the question of what other procedures or steps one might take to resolve boundary disputes. And obviously the first one that comes to mind, and for all of us, of course, is the court procedure. But we all know, we'll have plenty of experience of that. That is equally, perhaps not quite as time consuming, but certainly as expensive and as stressful for the parties going through it. The other thing about the court procedure is it's also limited to an extent, in the sense that the court is limited to the remedies that it can grant and are sought by the parties, whether it be a declaration as to where the boundary is, whether it be an injunction, damages, and so forth. And sometimes, as we know in these disputes, the root of the issue is something different. Obviously, the parties hang their pegs on, they hang their case on legal pegs to bring their dispute to court and try and get some sort of resolution. But there can be all sorts of issues driving these disputes, as we all know. So unsurprisingly, you may think, with my mediator's hat on, I would obviously strongly recommend everybody to think about it at least. It's not ideal in every situation, and also the timing of it is important. A mediation taken at the right stage has a good chance of success. But the thing about mediation, as I'm sure many of you will know, is that obviously it offers so many more options to the parties, whether it offers the opportunity to do some further conveyancing, granting rights of way, creating restrictive covenants, or whatever it is. So there are more options available than even in court, and certainly more than the determined boundary jurisdiction, which, as you can see, probably has its limitations where there's any kind of dispute. I mean, where the that there's an agreement between the parties, whether it be a boundary agreement or otherwise, and the application isn't going to be opposed, then plainly that's an appropriate time to be maybe making an application. But if there's any kind of dispute as to where the boundary is, or there's likely to be, then I think you can probably see the limitations of the jurisdiction. But Carl, I mean, perhaps you could share some of your thoughts on this with us, because I know that you also get involved in other kinds of alternative dispute resolution. So perhaps you could give us some thoughts on alternative means of resolving boundary disputes.
Well, thank you, Simon. Yes, there's one that I've been involved with quite a few times is expert determination according to English law. That's law of England and Wales, of course. This has two main problems. One is, what is the law? Because I have to know something about it. Okay, fortunately I've got a CPE and a Master's in Law, but that's by the by. The other thing is, what are my instructions? They need to be understood by me. One party might decide that, well, these are the instructions for Mr. Calvert, and the other side might say, well, these are the instructions, and they might conflict. So the first problem is actually getting both parties to agree a set of instructions. And then I have to do the job. Well, in a way, it's a bit like going to court, because if you can't solve it by mediation, you're giving it to someone else to solve, and you never get the result you wanted. You might get the result that you can live with. So that's expert determination. I have had one where I did an expert determination. One side didn't like it, so they employed another surveyor, who then criticised me and said, well, actually, if you had measured from here, you would have got a different answer. To which my reply was, when I did my survey, the place where you started hadn't existed. So you come back to this point of, where do you start measuring from? And there's a very good quote from Lord Jacobs in a case of Horn and Phillips, where Lord Jacobs said, well, we've got this 60 metres and we know where it starts. I'm not interested in Ordnance Survey maps, whether they're right or wrong, but this is where it starts. This is the 60 metres and that's it. And what I've got here, when we say, where's it going to start from? It's all right, I'm not going to damage anybody or computer, but this is part of a permanent ground mark. And this cap goes inside it. I won't do it like that. And that is useful for determined boundaries, but also it's a very useful mark to have for surveys so that people can return to it. And thinking of returning to things, I shall return to Simon. So thank you.
Carl, thank you. I mean, that's some interesting thoughts on yet further means of resolving disputes. But I think one of the interesting things you touched on there was control, because as you said, even if you if you decide to go down the boundary, the expert determination route, you're handing over control. Yes. To somebody else yet again, in the same way that if you go to court, you hand over control to a judge. If you go to the tribunal, you hand over control to the tribunal judge, and that's obviously introduces an element of doubt, risk, potential expense, and so forth. Yes. It does really bring us back to mediation. Yes. Because that is one of the beauties of mediation is obviously that you retain that control. You have the opportunity to decide whether you agree and on what basis. And so if you're advising your clients as to how they might try and resolve the dispute with a measure of retention of control, then that's certainly the one of the things to consider. Just before we go into the questions, I mean, just on the question of mediation, there's one important and helpful comment made recently. I don't know if you picked this up by Sir Geoffrey Voss, the Master of the Rolls, when he was speaking, I think earlier this year at Hull University, and he was talking about mediation, and obviously you may know there's a discussion going on as to whether and to what extent it should be made compulsory in the litigation process. And what he talked about was the sweet spot for mediation. And this is an important thing. It's the timing of it. When is the optimum time to have a mediation? What he was thinking about was, in particular in relation to boundary disputes, as I said earlier, that it's important that you obviously have the right evidence available before you go to mediation. But obviously, what can happen, as Carl and I know, because there was a mediation in Woodhead and Witt, but it came very late in the day. And Carl, I don't know if you remember, obviously we can't disclose the details of the mediation, but inevitably, as it always happens in a mediation, there came a time when the costs incurred were being discussed, as they always are. And because the mediation was so late in the process, the parties are already both incurred significant amounts of costs, and that was an issue. And that's why, well, one of the reasons why agreement wasn't reached at the mediation. So it's very important to time the mediation, if you're going to have one, as best you can. So you've got the right information, but you haven't spent too much money.
I think
yeah, go on. You've got something.
Okay, there's another point. I was out yesterday afternoon to see a potential client, and the house had been built by his father-in-law, who was an architect also of the city, and the amount of land was very small. It was about 3 inches, 4 inches at one end, and I said, what is the advantage or disadvantage that you have if you lose that piece of land? Will you still be able to maintain the boundary? Answer, yes, I got on very well with my neighbours. So if you get on very well with them, what is the advantage of trying to claim back that land? How much will it cost? And do you want to move? Or do you want them as neighbours? Because if it gets really difficult, one side or the other won't want to live next door to the other person. So maybe it's a question of just speaking to them. And if you like, I can go and speak to them and say, look, this is what the problem is. And I think what we'll do, we'll leave it at the status quo, but allow my client in to maintain the fence, which is what we decided to do.
Yeah, well, effectively.
So right at the beginning, you get them to sort of wind their neck in, I think is a military expression.
Yeah, absolutely. Well, you were effectively mediating the dispute there and then, Carl.
Yes.
Those are, of course, all the mediators listening to this will, those are precisely the sort of questions in your testing sessions with each of the parties that you ask them to try and get them to really focus on A, what's driving the dispute, and B, how it might be resolved to everybody's mutual satisfaction. So that's, Carl, that's great. That's a really helpful example, proving the point in a case that you were dealing with just yesterday. Yeah, sure.
And it only took an hour.
Yeah, absolutely. Yeah. Well, there we go. Yeah, brilliant. We have had one question asked in advance, which was about the timing of the determined boundary application process. And you may already have got a clue from what we've been saying about the time of the proceedings in Woodhead and Witt. I mean, obviously that case went to the upper tribunal, but of course, if there's an appeal, any case might. But it's a long process because from the moment you apply to the land registry, there is a drawn out process within the land registry before they then refer it up to the FTT if there's going to be a dispute. So you're going to be looking at several months, if not getting into a year or more, simply with the land registry process, possibly another year in the process at the FTT if it's disputed. And then, I mean, again, another year or so if there's an appeal. So it is, I'm afraid, a very long, drawn-out process. Okay, well, look, thank you for listening, if you have been, and hopefully that's been useful. Feel free, and I'm sure Carl will agree, if you've got any questions that come to mind later, to make contact with either of us. Be more than happy to answer those.
Yes.
So for now and until then, if it's going to be, thank you for listening. And
Yes.
good morning, good afternoon almost. Cheerio. Bye-bye.
And it's goodbye from him and it's goodbye from me.
Yeah. Thanks, Carl.